Are you still using the same contract template for every customer or supplier? Whether it's service agreements, terms and conditions for a website, supply contract, or a subscription, there's a real chance now that those contracts could be illegal. And if the ACCC comes knocking, the penalty could be in the millions. So here's what's changed and what you should be doing about it. Since November 2023, Australia's made major law changes to their unfair contract terms. Before this, if a term was unfair, it was simply voided. There are no real penalties. Now, that's changed. Amir, could you break down what this actually means for businesses?
Unfair contract terms are now illegal, not just unenforceable. Since November 2023, using or relying on unfair contract term can attract significant financial penalties. And more importantly, each unfair term is treated as a separate contravention. This basically means that if a contract contains 3 problematic clauses, there could be 3 separate penalties. Now the laws also apply to more and more small and medium businesses. A business qualifies if it employs fewer than 100 people or has a turnover under 10 million in the previous year. In addition, the definition of a standard form contract is actually broader than many people realize. Even minor negotiation does not necessarily remove it from that category. And the ACCC is actively enforcing these changes.
So, what actually makes a term unfair? What should business owners be looking out for?
It is considered unfair if 3 elements are present. First, it creates a significant imbalance in the parties' rights. Second, it's not reasonably necessary to protect the legitimate interest of a party. And third, it could cause financial or other detriment to the other party. That basically means, and if we can use some simple examples, an auto-renewal clause without adequate notice, unilateral variation clauses allowing only one party to change the terms without consent, broader termination fees, one-sided indemnity. There are many examples we can use, and that's why it's important to go through each clause and make sure that it doesn't have any of those elements.
All right, this is the part that really matters. What are the risks if businesses don't fix this?
The financial penalties are substantial. For corporations, the maximum penalty per contravention is the greater of 50 million, or 3 times the benefit obtained, or 30% of the corporation's adjusted turnover during the breach period. For individuals, including directors, penalties can reach 2.5 mil per contravention. Each unfair clause is treated separately. That basically means that the exposure can multiply quickly. And the ACCC does not need to wait for a complaint to start investigating. It can proactively investigate industries. The enforcement action is public, and that basically means that there's a great risk of reputational damage to the business.
So the good news is, this is fixable. What should businesses be doing right now?
The advice we give to all business owners is to conduct a comprehensive audit of every standard contract they use. That could include terms and conditions, service agreements, supply agreements, subscription agreements, and contractors agreements. They should identify high-risk clauses, especially unilateral variation rights, termination fees, one-sided liability caps, and automatic renewal clauses without clear exit options. For each clause, the key question should be whether it genuinely protects the legitimate business interest, or does it simply shift the risk unfairly to the other side. Where necessary, balance should be introduced. And finally, businesses should document their review process and reasoning.
If your contracts haven't been reviewed recently, now is the time. At XARY, we help businesses identify risk, fix unfair terms, and protect what they've built. Reach out to the team at XARY to make sure that your contracts work for you and not against you.